Tuesday, November 3rd, 2015, AD. Last Prophet Ronald Dwayne Whitfield. United States of America. Email, andykomanilavim@gmail.com. The International Criminal Court. Mrs. Fatou Bensouda, Prosecutor. Mr. James Stewart, Deputy Prosecutor. Mr. Luis Moreno Ocampo, Chief Prosecutor. Office of the Prosecutor. P.O. Box 19519/2500. 2,500 centimeters. The Hague. The Netherlands. Telephone number +31 070 515 8515. Email, otp.informationdesk@icc-cpi.int. Email, po@icc-cpi.int. Email, publicaffairs.unit@icc-cpi.int. Fax +31 070 515 8555. Criminal complaint for crimes against humanity. Rome Statute 5, Article 7. Dear Sir or Madam, enclosed, please find and process my complaint for crimes against humanity, the violation of Rome Statute 5, Article 7, and same be processed and immediately brought to the attention of our Honorable Prosecutor and the judges of our International Criminal Court for an investigation by the prosecutor and an adjudication by the court through the lawful processes of the court. Thank you. And with kindest wishes, I am. Signed by Ronald Dwayne Whitfield. CC, Offices of the U.S. President and Attorney General. CC, U.S. Congresswoman Sheila Jackson Lee. Dear readers. Dear readers. Title 22 U.S.C. contains such international laws, previously being just bills made by our Congress, and passed to and later being signed into law by our presidents, in pursuance to treaties of the United States of America, and subject to the jurisdiction of the International Criminal Court, which is empowered to hear allegations of violations of our international laws, and to adjudicate such allegations, and render judgment upon violations of said laws to which even our great United States of America is subject, and whose judgment is subject to enforcement by our United Nations, or some other power, or otherwise such court would become and be made a mockery. The International Criminal Court has criminal power, or jurisdiction to bring to trial, and adjudicate individuals in the American political and legal systems for their commission of such crimes against the people, and whom are subject to the jurisdiction, the United States of North America, as alleged against humanity, the offenses of which have been in the past, and are still being committed today, and through the American legal system, which is so corrupt that it is almost beyond recognition, as described below by our last prophet named herein and substantiated by an American jurist, the Honorable Circuit Judge Edith Jones of the United States Court of Appeals for the Fifth Circuit. The American legal system is corrupt almost beyond recognition. Criminal complaint. Last Prophet Ronald Dwayne Whitfield, acting on behalf of himself and all other citizens, subject to the jurisdiction or power of the United States of America and of the state of Texas, complainants. Against the United States of America and the state of Texas, defendants. Last Prophet Ronald Dwayne Whitfield's criminal complaint and supporting affidavit for crimes against humanity committed by the American legal system, which is corrupt almost beyond recognition. To the Honorable Judges of and Prosecutor for said court. To the Government of the United States of America. Now comes our world's last prophet Ronald Dwayne Whitfield, and appearing before the world, and in this international court, and in the Government of the United States of North America, in propria persona, would respectfully show as follows. Jurisdiction. Jurisdiction. A. The jurisdiction of the Government of the United States to hear this petition is provided by the First Article Amendment to the original Constitution for the Government of the United States of North America, and the jurisdiction of this International Criminal Court to consider or hear the alleged facts or legal claims presented herein and adjudicate same to a final decision is as provided by the Roman Statute 5, Article 7. 1. For the purpose of this statute, crimes against humanity means any of the following acts when committed as part of a widespread or system attack directed against any civilian population with knowledge of the attack. A. Murder. B. C. Enslavement. D. E. Imprisonment or other severe deprivation of physical liberty in violation of fundamental rules of international law. F. Torture. F. G. H. Persecution. I. J. J. K. Other inhumane acts of a similar character intentionally causing great suffering or serious injury to the body or to mental or physical health. A. Attacks directed against any civilian population, i.e., coronavirus, means a course of conduct involving the multiple commission of acts referred to in paragraph 1 pursuant to or in furtherance of a state or an organizational policy to commit such attacks. B. C. Enslavement means the exercise of any or all of the powers attaching to the right of ownership over a person. D. E. Torture means the intentional infliction of severe pain or suffering, whether physical or mental, upon a person in custody or under the control of the accused. Except that torture shall not include pain or suffering only from, inherent to, lawful sanctions. F. G. Persecution means the intentional and severe deprivation of fundamental rights contrary to international law by reason of the identity of the group or collectivity. H. I. B. Is indeed truth stranger than fiction? If the United States Supreme Court be correct, that truth is stranger than fiction, then last prophet Ronald Dwayne Whitfield may very well be in fact our last prophet, as he is so claiming and contending to be. 2. Principles of decisions. Owing to the seriousness of the allegations presented herein, we begin by demonstrating for the readers that we are mindful of the basic way that our American legal system works. To be convincing when you write, and when you speak, example, our last prophet leaving the federal courthouse, in custody of prison guards after a naive jury having heard his complaint based on claims of violations of the 8th and the 14th Amendments to the United States Constitution, having been beaten while in handcuffs, and thus not an authorized use of force nor an excessive use of force, because such state action was not authorized at all, but constituted an aggravated assault. A criminal offense, just like in the Rodney King case wherein the federal government was essentially forced to seek and prosecute such returns of bill of indictments, and therefore recognized in and protected by Title 18 U.S.C. Section 242, but the American legal system systematically and unlawfully deprived prisoners of inalienable rights, and thus mischievously deceive prisoners into thinking and believing that such claim falls under an enabling federal statute for the redress of claims for violations of civil rights described by Title 42 U.S.C. Section 1983, such as an authorized use of force that became an excessive use of force, which merely provides a vehicle to simply redress such a violation. In Abilene, Texas, on Tuesday, July 5, 1994, AD, shouting in front of television cameras and such news reporters that our government is corrupt. Are you going to appeal it? That's what they want. You need to back up your opinion and claims respecting an assertion of facts stated in this complaint brought against the American legal system, with reasons and evidence. Nobody is going to believe that what you say is true. Example, I am real God's last prophet, or I, Melinda Harmon, do solemnly swear, or affirm, that I will administer justice without respect to persons, and do equal right to the poor and to the rich, and that I will faithfully discharge and perform all the duties upon me as United States District Judge under the Constitution and laws of the United States. Oh help me God, just because you say it. You need to build a sound, logical argument, consisting of your opinion, reasons, facts, and evidence. Justices of the First Court of Appeals of Texas and Judge Baker. My car was stolen today. I now present this also to you as for what you call an emergency motion for contempt of court and for hearing, and also that you cause this matter be forwarded to the Harris County District Attorney's Office for a criminal investigation for theft of my vehicle, which vehicle is the factual basis establishing the subject matter jurisdiction to hear the case, and which is pending in these courts against both Big Star Honda and her attorney of record. Inna. Offices of the President and the Vice President, and the United States Attorney General, and her Department of Justice. Supreme Court. Number 98 to 9085. United States Court of Appeals for the Fifth Circuit, and United States Court of Appeals for the Fifth Circuit Judicial Council. Numbers 15 to 4130, 15 to 41304, 15 to 41306, 15 to 20558, 15 to 20547, 97-00454, 03-20424, 05-15-90111, 15 to 41298, 15, 15, 15, 15, and 15. In re. Prophet Ronald Dwayne Whitfield, Petitioner and Appellant. United States of America, Plaintiff. Against the State of Texas, former and current magistrate, and district judges, former and current justices of the First and the 14 Courts of Appeals of Texas, and former and current district clerks and district attorneys of Harris County, Texas, defendants. In the Court of Criminal Appeals and Supreme Court of Texas. Number 25869 to 90, criminal. Number civil. Ex part, Prophet Ronald Dwayne Whitfield. Relator, applicant and petitioner. In re. Prophet Ronald Dwayne Whitfield. Petitioner. In the Offices of the President and the Vice President numbers. Last Prophet Ronald Dwayne Whitfield's petition to President Obama and Vice President Joe Biden to sign and issue an executive order AS will enforce and preserve the United States Constitution, based on the information set out below, and in the accompanying documents. In the United States Supreme Court. Numbers 98 to 9085 and Prophet Ronald Dwayne Whitfield's motions for leave to sue out these proceedings in forma pauperis, and to reopen, and for the justices of said court to observe the judicial action previously taken and to be taken in the proceedings below, and bringing a formal demand for a judicial determination of this void sanction order, AS rendered without power or jurisdiction, AS based on the court's own decision, as announced in Steel Company v. Citizens for a Better Environment, 118 S.C.T. 1003, 1998. In the United States Court of Appeals for the Fifth Circuit, and United States Court of Appeals for the Fifth Circuit Judicial Council. Prophet Ronald Dwayne Whitfield's formal demand for a judicial determination of void sanction orders for want of jurisdiction, thus being rendered without judicial authority on part of the judges acting for the court, and motions for rehearing on Judicial Council's order dismissing petition for review of Chief Circuit Judge Stewart's order dismissing complaint for judicial misconduct brought against U.S. District Judge Sim Lake for his willful refusal to comply with the law and court rules as imposed upon him by the Code of Judicial Conduct, and motion TOSUEOUT in forma pauperis, without having to pay, in advance, the costs pursuant to 28 U.S.C. Sections 1914 and 1915, A, with supporting 28 U.S.C. Section 1740 SIXS affidavit. These formal proceedings, and lawsuits escalating to their appeals, also brought by demand to challenge not the orders and the judgments of the lower courts on the merits of the case, but to challenge such as void for want of jurisdiction to proceed without jurisdiction in the case. A void order or judgment may be attacked anywhere, and at any time, because it does not affect legal rights, and is a complete nullity from its inception, and is not entitled to respect. In the Court of Criminal Appeals and Supreme Court of Texas, numbers 25,869 to 90 criminal. Number civil. Prophet Ronald Dwayne Whitfield's petitions and motions for leave to file in criminal and in civil law matters such petitions for writs of mandamus to the 174th, 295th, 333rd, 337th, and 351st Judicial District Courts of Harris County, Texas, and to the 1st and to the 14th Courts of Appeals of Texas. To our honorable real God. To the judges of the International Criminal Court. To the President Obama. To the Vice President Biden. To all the members of Congress. To the United States Attorney General. To the aforesaid state and federal judges and justices of the state of Texas and of the United States federal government. To the governor of the state of Texas. To the lieutenant governor of the state of Texas. To the members of the legislature of the state of Texas. To the representatives of the Public Integrity Unit and members of the Texas Rangers of the state of Texas. To the people of the state of Texas. To the American people. To the people of the world over. In the 113th, 133rd, 295th, and 333rd Judicial District Courts of Harris County, Texas. Trial Court Cause Numbers 2015 to 45,473, 2015 to 19,565, 2015-08974, 2015 to 22,666, and 2015 to 22,882. Prophet Ronald Dwayne Whitfield, Plaintiff. v. Big Star Honda, ETAL, Defendants. Prophet Ronald Dwayne Whitfield's motions for recusal of judges of the 133rd and 295th Judicial District Courts of Harris County, Texas, for hearings to hold both counsel for Defendant Big Star Honda and Defendant Big Star Honda herself in contempt of court. To strike the motion of counsel for First Service Credit Union for counsel's failure to both conference with Prophet and plaintiff regarding counsel's motion to dismiss for counsel's failure to include a certificate of conference with his. Said motion AS is required by Texas Rules of Civil Procedure, were this case brought before our U.S. Federal District Judge Samar Cummings, IT is likely here, too, that he would have ordered such a motion be stricken from the record on his own motion, protecting my rights, for sanctions, to compel discovery, and response of Prophet and Plaintiff Ronald Dwayne Whitfield T.O. said counsel's motion T.O. dismiss, and affidavit of indigency in response to ruling of Judge Baker from oral hearing allowing time to amend affidavits to provide judge with the legal authority of U.S. Supreme Courts holding that all these counsels have been in legal error to have contested in the first place such affidavits of indigency, that the Prophet's original and first amended affidavit are, and were sufficient already. Suffice it now to say, all legal terms used herein are to be understood to mean exactly what they legally mean, e.g., court means just that, and institution vested with power, and the right to act within the limits of that power, whereas the legal term judge means a natural person of flesh and blood authorized to exercise power for the court, frivolous, render, enter of record in the minutes of the court, judgment, punishment, sentence, conviction, and so on all have legal definition, either established by Congress, the Texas legislature, or construed by judges and justices acting for courts. Preamble. Our greatest prophet ever, Jesus, knew their thoughts, and said to them, "Every kingdom divided against itself will be ruined, and every city or household divided against itself will not stand." If Satan drives out Satan, he is divided against himself. How then can his kingdom stand? Our Holy Bible. In Re Toma, 873 SW2D 477, Texas Review Tribunal 1994. Whereas a corrupt state court judge divided against the corrupt legal system in the kingdom of the state of Texas, just like Prophet Jesus stated, that corrupt kingdom would be, and was being ruined, and therefore, the said corrupt kingdom of the state of Texas was forced to drive out former Judge Tomal. Believe it or not, in the state of Texas, and in all other states, Prophet Ronald Dwayne Whitfield, and his business named Ronald Dwayne Whitfield, and any other natural person of flesh and blood, can now be legally, criminally, and civilly sued or charged by her Harris County Attorney, and by her Harris County District Attorney, prosecuted by her Harris County District Attorney, represented by her judge or court-appointed attorney, and tried by her very own presiding judge and due process. Will not be offended today? The record in the instant case establishes that on January 9th, 1992, which just so happened to be the same day that both former President George H.W. Bush collapsed overseas in Japan, and the state of Texas, corruptly, and, therefore, unlawfully, caused such non-signed and non-filed docket sheets in a purported criminal lawsuit being styled the State of Texas v. Ronald Dwayne Whitfield, in cause number 617718, and in her very own court, the 174th Judicial District Court of Harris County, Texas, to reflect that he somehow had been and legally and criminally indicted for commission of crime, but today the records of the District Clerk of Harris County, Texas, disclose that that purported indictment was found, but by an action of a non-existing grand jury, for I can't give you something that don't exist, purporting to be presented to a deputy district clerk who was just sitting or standing in a courtroom, and by him, or her to be then passed to Judge Hearn, a judge of a court other than where the criminal complaint was purportedly filed, and proving such a judge will have still otherwise acted without an existing paper order being contained in the file of the cause itself and entered of record on the minutes of the court, and thus transferring the case from the 174th District Court to the 263rd District Court for grand jury proceedings, and thereafter ordering the case be transferred back to the 174th District Court for disposition of the indictment. Both courts would have had no jurisdiction over what purported to be a then pending case, to purportedly be inspected by this former Texas State District Judge, Charles Hearn, whose signature and happy face is already affixed to a pre-printed order of presentment of indictments whereon blanks are left to create the dates for the presentment of purported indictments, and on an order he sent to prisoner then on death row, affording him legal notice of the date for his execution, having Judge, what you got? Judge, what you got? Judge. The record in the instant case establishes that on January 9th, 1992, which just so happened to be the same day that both former President George H.W. Bush collapsed overseas in Japan, and the state of Texas, corruptly, and, therefore, unlawfully, caused such non-signed and non-filed docket sheets in a purported criminal lawsuit being styled the State of Texas v. Ronald Dwayne Whitfield, in cause number 617718, and in her very own court, the 174th Judicial District Court of Harris County, Texas, to reflect that he somehow had been and legally and criminally indicted for commission of crime, but today the records of the District Clerk of Harris County, Texas, disclose that that purported indictment was found, but by an action of a non-existing grand jury, for I can't give you something that don't exist, purporting to be presented to a deputy district clerk who was just sitting or standing in a courtroom, and by him, or her to be then passed to Judge Hearn, a judge of a court other than where the criminal complaint was purportedly filed, and proving such a judge will have still otherwise acted without an existing paper order being contained in the file of the cause itself and entered of record on the minutes of the court, and thus transferring the case from the 174th District Court to the 263rd District Court for grand jury proceedings, and thereafter ordering the case be transferred back to the 174th District Court for disposition of the indictment. Both courts would have had no jurisdiction over what purported to be a then pending case, to purportedly be inspected by this former Texas State District Judge, Charles Hearn, whose signature and happy face is already affixed to a pre-printed order of presentment of indictments whereon blanks are left to create the dates for the presentment of purported indictments, and on an order he sent to prisoner then on death row, affording him legal notice of the date for his execution, having Judge, what you got?
Having no names of the witnesses whose testimony, or rather upon whose testimony, the same indictment was found, and having no fact of presentment of indictment by a grand jury, which shall be entered of record in the minutes of the court. If the defendant is in custody or under bond, as mandated by her very own laws. Texas Code Criminal Procedure, Articles 20.20 and 20.22, to therefore answer up to the so-called charge of burglary of a building with him having intent before entry to rescue no mother's baby nor to put out any fire, but merely to commit an $80 theft of personal property, a misdemeanor, and therefore it was felt and justified that he be sued out by the same said state of Texas, as through the office of her district attorney of Harris County, a conversation took place in the courtroom, or rather in the stairwell of the Galveston County courthouse between respondent Judge Tama, in which the following was discussed.
Judge, what you got? Judge, oh yeah, that's what I'm saying is that apparently what got? Judge, I guess so if he told me. Judge, oh yeah, that's what I'm saying is that apparently what happened is that it was on the docket sheet, but it didn't get transferred over to the, judgment papers, and that's what the probation department gets. This happens all the time where they fill in the judgment form, and it's different from what actually occurs in the courtroom on the docket sheet. So what's your phone number? Judge, I guess so if he told me what was happening, should I be worried about it too? Goddamn, I tell you shit man, your nuts are going to jail man, some big nigger going to be fucking you in the ass for the next 2 years. Matthews, now that's when they get me on the murder charge. Go out this door or that one? Mendez, no, I saw. Judge, were you parked? Matthews, right there. Judge, go out that door. Needless to say, any definition of the word corrupt will suffice herein, whether that definition be illegal or a common one. Dear readers, dear readers, dear readers, dear readers, I will have convince and persuade do not mean the same thing. Convince and persuade do not. Dear readers, I will have drafted this lengthy, for example, once our dear readers, I will have drafted this lengthy petition in my role as paraclete, defined as a wise counselor, a prosecutor. Convince and persuade do not mean the same thing. We convince someone that something is or is not so, but we persuade someone when we get that person to take, or to not. For example, once our last prophet, our paraclete. Convince and persuade do not mean the same thing. We convince someone that something is or is not so, but we persuade someone when we get that person to take, or to not take some particular course of action. For example, once our last prophet, our paraclete, that is, one acting in the role of a prosecutor, an advocate, or intercessor, convinces the world that he truly is real God's last prophet, convinces the world to be in the wrong about sin, and about righteousness, and about judgment, wrong about sin because we people actually do not believe in our great prophet Jesus, about righteousness because prophet Jesus went back to be with our real God, such that neither his first disciples saw nor we. His last disciples see him any longer, through the eyes of his first disciples, and about judgment, because the prince of real God's world now stands condemned already, and that the American legal system truly is corrupt almost beyond recognition, he will easily persuade them to take a particular course of action, to repent and on today, not on tomorrow. Now, whether or not you be real God-fearing, and whether or not you be either having true love, and real respect for law, and for order in any society, and having genuine love for our country today, and for our future on tomorrow, or that you have none whatsoever, please still keep reading this petition. At the outset, all such cases herein cited serve as the proof or the evidence proving that which I state as being both true and correct, and any licensed attorney, who is not subject to practice law in courts in, and having geographical jurisdiction over the state of Texas may, without fear and retribution, go on television, and confirm that which all I have stated below, as far as the law is concerned, is so very true, and that not only has Texas, unlawfully, carried out unlawful sentences of death and of incarceration in the face of purported judgment, of Harris County, Texas, but also such evils now, and do constitute an unlawful motive for both the government of the state of Texas, and the federal government to cause, unlawfully, death and or incarceration of me, so as to avoid being exposed. An American legal system being already corrupt almost beyond recognition will soon break down, and has just like a car sometimes does, and therefore without such a legal system in our form of government remaining set up and properly functioning, we therefore can have no government at all, for each branch is essential to the other two in our real God society. And if our said legal system in fact be truly corrupt almost beyond recognition as stated by Judge Jones, if not now, then, our question is, just exactly when do we fix this motor in our car, or shall we just buy a new one? Please, and what be of the legal and financial ramifications on the legal, political, and executive systems of government in the state of Texas, and on when even our presidents and our members of our Congress have all had enough and finally come out to admit to you of this and of what all I have told you be in fact true? There surely will be public outrage of the highest magnitude, for since this corruption has already happened to someone else it can also happen to you, and so you can now see, by this petition, that with or without the assistance of a lawyer, you too would be now, and would have been then, in the shoes of another, treated no differently. See John 14, 16-17, and 26, 15-26, and 16:7-15, Holy Bible. At the end of this section in this petition, this document will truly go on to explain to its readers about when, where, why, and how I became our real God's last prophet, and so you are now encouraged to then conduct your own investigation into this and to ponder on how and why Texas, through her parole board, unintentionally, and thus inadvertently allowed me to become released to parole from her hell, just to now successfully and finally expose her worldwide, thus previously struggling from prison cells of Texas, and now here in society still doing exactly all the works our great prophet Jesus declared unto his first disciple that I would do after he would go away. And I tell you the truth, he shall not return unto the earth until each work, as declared by him, and recorded and entered of record in the minutes of the book of John, has been accomplished. See John 16, 7-15. Now comes Prophet Ronald Dwayne Whitfield, in propria persona, not pro se, and, in his role of our paraclete, he would respectfully unto you show. Introduction. 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 The American legal system is corrupt almost beyond recognition. Judge Edith Jones of the U.S. Court of Appeals for the Fifth Circuit told the Federalist Society of Harvard Law School on February 28. MassNews.com, March 7, 2003. So also in hell, I moved to sue Texas in federal court on such legal theory.